In 2004, a Texas court ordered a man to hand over an idea that existed nowhere but inside his own head. He hadn't written it down, he hadn't coded it, he hadn't sketched it on a napkin, and a judge still ruled that his employer owned it, backed by the threat of contempt of court if he didn't explain it out loud. If you've ever signed an employment contract without reading past the first page, there's a clause buried in it that may already own your next side project, even the one you haven't started yet. That clause has a name, an Invention Assignment Clause. It's a section of your employment contract, usually signed on day one, usually never negotiated, where you agree that anything you invent during your employment belongs to the company. Not just what you build at your desk, potentially anything, depending on where you live and how the sentence is worded. According to a 2026 review of employment contracts by legal tech firm Justi, 61% of technology sector employment agreements contain intellectual property clauses broader than what state law actually allows, reaching into personal side projects built entirely off the clock. The man in Texas found that out the hard way. But before we get to his case, you need to understand where this clause came from and why courts let it get this powerful. For most of American legal history, the law actually favored the inventor, not the company. The Constitution itself says patents belong to authors and inventors, not employers. If you built something brilliant on the job in the 1800s, it was still legally yours, unless you'd signed something saying otherwise. Courts eventually carved out two exceptions. The first is called a shop right. If you invent something at work, using company tools, on company time, your employer gets a free license to use it. Not ownership, just permission. The second is the hired to invent doctrine. If a company specifically hires you to solve one exact problem, and you solve it, the invention is theirs, because that's literally the job they paid you for. Both of those doctrines required a judge to look at the specific facts of a specific case. Companies hated that uncertainty. So, starting in the mid-1900s, they stopped waiting on judges and started writing the outcome directly into the hiring paperwork. That's the Invention Assignment Clause, and it doesn't ask what you were hired to do. It just claims everything, upfront, before you've invented anything at all. 10 states eventually pushed back, passing what are sometimes called freedom to create laws. California, Illinois, Washington, Minnesota, Delaware, and New York among them. California's version, Labor Code Section 2870, is the model most of the others copied. It says a company can't claim an invention you built entirely on your own time, with your own equipment, unless it relates directly to the company's actual business or its planned research. That sounds like solid protection. It isn't. Not entirely. And that gap is where most people get caught. But here's the part almost nobody mentions. In states without one of these laws, Texas, Massachusetts, Florida, and Washington, D.C. among them, there's no statutory floor at all. Whatever the contract says, goes. Full stop. That is exactly the machine that caught Evan Brown, the man from The Hook. Brown worked in technical support at DSC Communications, later bought by the telecom giant Alcatel. For over 20 years, on his own time, he'd been chewing on a way to translate old legacy computer languages into modern code. In 1997, on a weekend road trip, he finally solved the last piece of the math. Entirely in his head. Nothing written, nothing built. Brown tried to bring the idea to Alcatel as a partnership. He'd get a share of the profits if the company developed it. Alcatel's response was to fire him and sue him instead, pointing to the Invention Assignment Clause he'd signed years earlier, which claimed all inventions made or conceived during his employment. Here's the legal term that decided the case. Conceived. Courts have long treated an invention as legally real the moment it's fully worked out in someone's mind. You don't have to build it, patent it, or write it down for it to count. Alcatel's lawyers argued that Brown's clause captured the idea the second the math clicked into place on that drive. The court agreed. It ordered Brown to disclose the algorithm from memory under threat of contempt, meaning if he refused, he could be jailed for withholding property that, legally, was never his to begin with. An idea with no paper trail, owned by a phone company because of a clause Brown signed years before he ever thought of it. If you're thinking Brown just had unusually bad luck, look at Cubic Corp versus Marty. An engineer designed a military training simulator entirely on his own time, on his own equipment, checking every box California's law requires. He still lost. Why? Because the simulator overlapped with his employer's actual business. Courts call this the field of business test, and it's brutally wide. Your project doesn't have to compete with your employer directly. It just has to sit in the same industry. A fintech engineer who builds a budgeting app on weekends. A game developer who prototypes an indie title in their spare time. Under this test, both are exposed, even with zero company resources involved. Brown appealed. He lost again. The Texas Court of Appeals upheld the ruling in 2004. The Texas Supreme Court declined to even hear the case. That refusal mattered. It let the ruling stand as precedent, not just for Brown, for every employment contract written in Texas since. The algorithm was never his. Legally, it never had been. Not from the moment the last equation clicked into place in his mind. Alone, in a car, on a weekend, 20 years into thinking about it. One clause, one sentence, signed at hiring, decades of unpaid thought, gone in a single ruling. So what does this actually mean for you? First, check your state. If you're in California, Illinois, Washington, Minnesota, Delaware, or New York, you have real statutory protection. But only if your project has zero overlap with your employer's business and zero contact with company resources. Slack messages about your side project count as resources. So does testing your code on a company laptop, even once. Second, look for a page in your onboarding paperwork called a prior invention schedule. Most people leave it blank. That's a mistake. An empty schedule creates a legal assumption that anything you finish during employment was conceived during employment. List your existing projects by name before you sign anything. And here's the detail almost no one budgets for. Courts have ruled that continued employment alone, no bonus, no raise, no new title, is enough legal justification for your employer to make you sign an even stricter version of this clause, mid-career. Refuse, and they can legally let you go. A court forcing a man to describe a thought that never left his own head is either dystopian or remarkably efficient contract enforcement, depending entirely on which side of the desk you're sitting on. So, if you've got a side project going right now, would you actually know whether your employer has a legal claim to it? Tell me your state in the comments. I'm curious how many of you are protected and don't even know it. If this is the first time you've thought about what's actually inside your own employment contract, subscribe. This channel exists to find the clauses nobody reads. And next time, a federal water law so strict that in parts of the country, simply catching rain in a barrel in your own backyard has landed people in criminal court. You want to see how that one actually works.